Droit Administratif. Droit Administratif is a French term, meaning the administrative law. Droit Administratif can be said as a body of rules of public administration, and it maintains the relation between the administration and citizen. Further, it formulates and determines the duties of the administration. Sir Ivor Jennings said, administrative law as a law relating to the administration. It determines the organization, power and duties of the administrative authority. The concept of droit administratif started to take shape during the French Revolution of 1789. There was a conflict among the two thought class, one traditionalist Bonapartists who supported the supremacy of the executive power, and the second was the reformist parliaments. They supported the administrative dispute to be under the jurisdiction of the ordinary courts. Both the third class overlooked the pre-revolutionary period of France, that is, Conseil du Roi. This body was armed with the executive powers under the king, which superseded the ordinary courts. After the French Revolution 1789, the concept has changed in the hand of Napoleon Bonaparte, who progressed the reform in the administrative justice and propounded Conseil d'Etat in 1799. The objective to form the Conseil d'Etat was to separate the executive. In 1873, Arent Blanco decided that Conseil d'Etat will deal with the administrative matters. It further decided that if there is a conflict between the administrative court and the ordinary court, then in such cases the matter will be decided by Tribunal des Conflicts. The concept of droit administratif was the outcome of the French Revolution. The objective behind the development of the droit administratif is to control the executive over activism. Let us now discuss the features of the droit administratif. 1. The rules of the administrative law will not be enacted by the parliament, rather by the judges of the administrative court. The judges will formulate the rules on A. Rules relating to the administrative authority and its officials. B. How to provide public services to cater the need of the citizens. And C. Procedure of administrative adjudication. 2. Any issue relating to the state and administration will go to the administrative court. In case of a conflict between the two, then such will be decided by the Tribunal des Conflicts. Conseil d'Etat is the highest administrative authority or court. 3. Droit administratif gives protection to the administrative officials from the ordinary law courts. The French jurist Wayne shows three basic principles of droit administratif. 1. The power of administration to take action suo motu and impose directly on the subject, and it is the duty to obey the decision. 2. The power which are conferred upon the administration, such as to act, impose, execute, such shall be within the cloth of the law, and it did not affect the individual's right. 3. There must be the presence of specified administrative jurisdiction. Dicey's concept of rule of law speaks about the supremacy of law, and all are subject to the ordinary law courts of the land. There is no special quarter for any particular section. All are questionable for their acts before the ordinary court of the land. The importance of judiciary is defeated if one goes against the rule of law. While discussing droit administratif, we have to take into account the situation from where the droit administratif arose. The objective of establishing droit administratif is to release the administration from the hand of the executive. The concept conveyed by Dicey is totally different from droit administratif. The concept of Dicey speaks about equal position of all, but droit administratif speaks about the special status of the administration and of the special court. Today we see a different view altogether, more inclined towards the Droit Administratif. We find the administrative tribunal a special forum for the administrative disputes. Not only in case of administration, there are also other specialized forum dealing with the various other chapters of law like labor, accident, cooperative, and so on.